Item number 1 and 2.
Yes.
I'm audible? Yes, Lordship, I'll continue with Air India Limited, 2002 SCC 617,
Paragraph 7.
Lordship, the last part, the middle part, Lordship, the state can choose its own method to arrive at a decision. It can fix its own terms of invitation to tender, and that is not open to judicial scrutiny. It can enter into negotiations before finally deciding to accept one of the offers made to it. Price need not be always be the sole criterion for awarding a contract. It is free to grant any relaxation for bona fide reasons if the tender conditions permit such a relaxation. It may not accept the offer even though it happens to be the highest or the lowest. But the state, its corporations, instrumentalities, and agencies are bound to adhere to the norms, standards, and laid down by them and cannot depart from them arbitrarily. Though the decision is not amenable to judicial review, the court can examine the decision-making process and interfere if it is found vitiated by malafide, unreasonableness, and arbitrariness. The states, its corporations, instrumentalities, and agencies have the public duty to be fair to all concerned. Even when some defect is found in the decision-making process, the court must exercise its discretionary power under 226 with great caution and should exercise it only in furtherance of public interest and not merely on the making out of a legal point. The court should always keep the larger public interest in mind in order to decide whether its intervention called for or not. Only when it comes to a conclusion that overwhelming public interest requires interference, the court should intervene. Then, Lordship, I'll go to...
Madam, this is the general law. It is quite right.
Lordship.
It is well known to everybody
Lordship.
that
So
discrimination, capriciousness, fairness, transparency, etc., etc., etc. Highest bid, lowest bid, best bid.
Lordship.
Yes.
Only when there is arbitrariness, when there is malafide, only the court will interfere, and court also will interfere where public interest is involved, Lordship. Here, Lordship, I wanted to cite 5 judgments regarding all these points, if Lordship permits.
We know all the.
Lordship. Then, Lordship, I'll just point out some. Lordship will come to my writ appeal.
The facts have been placed in the greatest detail. Please. The facts have been placed in the greatest detail right from invitation to tender till from technical bid, financial bid, then calling of the tenderers for some kind of a settlement, mediation, etc. Then some opting out, your client being selected. Now, please allow us to form our subjective opinion whether the law laid by these cases have been followed. That's all. In the facts of your case, whether we can say that there is no arbitrariness, no capriciousness, no discrimination, fair play, and transparent tender. So please allow us to do so.
Lordship, my very limited prayer, Lordship. I'll just, Lordship, note the facts well. Lordship, in para 11 of the judgment, I just wanted to put in why the single search has come to a conclusion. That is why I just want to point specifically only 2 paragraphs, Lordship, for your kind consideration, Lordship. Lordship, page 32 of my appeal, para 4. Only 2-3 lines I'll read, Lordship.
Yes.
Page 32, para 4 of my appeal. Page 32, Lordship. This is a part of the repetition.
Yes, it has further been submitted.
Yes, the learned has the last 4 lines, Lordship. The learned senior counsel has also contended that the evaluation of the technical bid is a condition precedent to evaluation of financial bids, and the respondents, by not adhering to the same, has initiated the entire tender proceeding. This is one part, Lordship. Then Lordship will come to page 58. This is the additional affidavit filed by the respondent 1. Only those two paragraphs, Lordship, I want to show. Page 58. Para 6. Lordship will, para 6, Lordship have found?
Yes.
Now, the petitioner respectfully states that pursuant to the aforesaid tender notice, the petitioner, along with 4 other tenderers, participated in the bid process. On 26, this is very important, Lordship. This is the way how the case was made up. On 26 July 2023, when the bids were opened, the bid prices of all the tenderers were revealed. And it was found that so-and-so, so-and-so, so-and-so had quoted identical rates, as it was found that the earnest was so-and-so, so-and-so. Then Lordship will kindly come to page 59, page 59, the 4th line onwards. Lordship have come. Page 59. Yes, Lordship. The 4th line. What ideally should have followed was that the respondent office ought to have immediately resort to the technical bids to evaluate. Lordship have found?
Yes.
What ideally should have followed, that was the respondent office ought to have immediately resorted to the technical bids to evaluate the competence of the bidders before making any award of work on the basis of the price bids. But the real scenario differed from what should have been the approach, and instead all the bidders were shown to have qualified in the technical bid process. Lordship, this is on this date only the financial bid was opened. This matter is proved by the fact. Lordship will kindly come to the additional affidavit filed by the government dated 11/2/25. Additional affidavit filed by the government dated 11/2/25. Lordship have come. Lordship, at page 10. At page 10, the type portion is in 11, the original one is in 10. So I take Lordship to the type 1, page 11. Yes, Lordship, page 11. Shall I read, Lordship?
Yes.
Attendance sheet for opening of technical bid on the 27/7/23 for the work construction so and so. And the persons present were the respondent number 1 himself at number 1. His signature is there in page 10, Lordship. He himself personally present before the technical committee. At serial number 1, his signature is there at page 10. By this, we come to a conclusion that technical bid was opened on 27/7/2023, not the financial bid, Lordship, where the respondent one was very much present on that day. He was very aware the technical bids were open. Then, Lordship, I'll take to page 19 of the same affidavit. Lordship, have found? Page 19. Opening of financial bid on 8/9/2023. The financial bid not open on 27/7/23 as projected by the respondent. This is the opening of financial bid on 8/9/2023 for the work construction of so and so, so and so. This is the original one. And Lordship, the signature was there. His representative attended at page 21. Odima Simpson at page 21, serial number 1.
Page 19.
Page 19, the attendance sheet. It is that that financial bid was open, and I wanted to show by 19 that on 8/9/23, this financial bid was open. It was never open on 27/7/23 as portrayed by the respondent 1. So page 21, at serial number 1, his representative signs because representative cannot attend the opening. And
so what happened on 27 July?
27, only technical bids were open. Lordship is very important. This is a two-bid system.
Yes. Oh, you are talking about the financial.
Lordship. 27 technical, 8/9 financial. Now they say they ought to have got evaluation for the technical bids. Lordship, technical bids is a pre-qualification before going into the financial bid, Lordship. They have to satisfy, and it is not like that they have done more work than me, more amount than me. No, it's not that. There's a parameter set. If you comply with the parameters, you are allowed. That is why in the representation they put the answer was put that you are qualified in the technical aspect. Every one of you are qualified. Only when the financial bid were open, his amount was ₹1.75 more. Here I make a submission, Lordship. Even a fraction. Now, just for an example, Lordship knows it very well. There is a 100-meter race. The first and the second, just 1 inch difference. Will the second come in the first, Lordship? Even if it's 1 inch difference when he reaches the time, it cannot be. Once he becomes an L2 bidder, there was no question of him for him to be called in that meeting. And very important point, Lordship, that another individual contractor who quoted the same, I have stated yesterday also, Mustafa Karkalar was never made a party in this petition. He was also the one who set for the negotiations. And somehow they decided that they will not do the work, they'll give the work, they will have no hesitation if the work is given to my petitioner. Now, Lordship, from all these judgments, had the administrative power been so arbitrary, so unreasonable, like the Wednesbury law, that the owner of the contract cannot go even into doing it that? Very wise enough, they have called all 4 of them to negotiate among them. They never interfered. Had this other 3 had said, no, we will not go with that, then the things would have been different. And this is a public project, Lordship. There's a public interest involved here. A stadium is being constructed for the underprivileged people, children in the village, Lordship. And so they thought wise that, again, even the tender authority thought that if they would have gone for a new tender after so long, might be the price would fluctuate in other conditions. Now, Lordship, the Apex Court on and on, again and again have said, the owner of the contract is the best one to decide. Even it is said, Lordship, even Article 14 violation, now it is said that it should not affect the award of the contract by the concerned authority, even if there is little here and there.
All right. We have understood.
That is my submission, Lordship. So there is no malafide, no arbitrariness, Lordship.
All right. But you just give us 2 dates.
Which Lordship?
If you have them, otherwise we will have the government.
I have Lordship will say, Lordship, can you tell me?
when was the bid made by the 4 tenderers? And when the bid was made, the offer was made by the 5th, Mr. Datto's client.
No, it was on the same day. 27th was the last day of filing the bids. And 27 only the technical bids were open. All of them filed in the same day.
No,
5 of them.
the financial offer.
Financial offer was 8/9/2023. This is not offer, Lordship. Financial bid was opened on 8/9/2023.
No.
It was in February 24, Lordship.
When?
If I'm not wrong. If I'm not mistaken, Lordship, I'll go to it. I'll surely give Lordship. In the month of February 24, and here I want to point out, Lordship, the 90 days of expiry period was also extended.
That is not important. When were the tender documents along with the offer submitted by each of the tenderers?
On 27 July itself. 27 July 2023.
All
of them. There were some discrepancies.
Well, that was 26th of July. 26th of July.
26/7, Lordship, 2023. All of them.
will submit it on the same day.
All same day.
Only the technical part was open on that day as per the tender notice, Lordship. I have pointed out yesterday, the tender notice says on 27/7/23, the technical bid would be open. Once the technical bid is open, Lordship, it goes under evaluation through various expert committees, Lordship. When these committees finds that any errors, they are asked to rectify. It has been done in this case. When every parameters goes, then it comes to the technical part, Lordship. It is not that there's a parameter set that you have to qualify. These are the conditions. If you satisfy, you are okay with the technical bid. Now you'll go to the financial bid. That is why after these technical bids were open, it was put before various evaluation committees. The technical experts, the financial experts, everyone went through them. And there were discrepancies.
What was the last date for submission of bids?
26/7/23 itself, when the technical bid was open.
27th it was open, 26th was the last date.
26 itself, the last time was 12 o'clock. Lordship, it's here. I'll point out, Lordship. Lordship will kindly come. It was done according to that, Lordship. Lordship will come at the tender notice, Lordship. I had pointed out yesterday. Lordship, at page 76 of my, at the relevant portion is page 78 of my writ appeal. '78, Lordship. Lordship have found?
Yes.
Lordship, at 17, italic 17. The bidding shall be on e-tendering basis. Technical bid part shall be open at 3 hours. Prior to that, I have to read 16 also, Lordship. Italic 16. Tender will be open in the conference halls of so and so on the same date, fixed time or receipt of the tender. The intending tenderers or the authorized agents may remain present at the time of opening the tenders if so desired. The tenders will be received up to 1 hour on the same day, Lordship, 26 July. Lordship found?
Yes.
And will be open on the same day at 3 hours. That means 15 hours, that is 3 p.m. It will be received till 1 o'clock, 1 p.m. and it will be open at 3 p.m. Tenders received later than the time prescribed above shall not be entertained. That means 1 o'clock of 26. Then, Lordship, that 17, italic, the bidding shall be e-tendering basis. Technical bid part shall be open at 15 hours on 26 July 2020 in presence of the bidders, representatives who choose to attend in the conference. The respondent number 1 was himself present as per page 10 of the additional affidavit filed by the government, dated 11/2/25. Now he makes up a case, Lordship, that there was no technical evaluation done. Lordship, two more things. I'll just point out two lines, Lordship. Lordship will come to page 154, Lordship, of my petition. This is the additional affidavit the respondent one files. Page 154, Lordship. Lordship, have found?
Okay.
154.
Yes.
10.1. This is how they have set up a case: a false, a lie, with all suppression of facts. 10.1. The evaluation of technical bid is a condition precedent to evaluation of financial bid. The question of consideration of financial bid arises only after a bid has been found technically responsive. This is very important, Lordship. That is why, Lordship, what the single judge says at 11, that single judge presumed that there was no technical evaluation done, Lordship. Then, Lordship, another only two lines of, I'll finish there. Lordship will come to page 32 of the writ appeal, the judgment. 32 of the writ appeal. Lordship have come. 32 para 4, the last 4 lines. Last 4 lines. The learned senior counsel has also contended that the evaluation of the technical bid is a condition precedent to evaluation of financial bids, and the respondents, by not adhering to the same, has vitiated the entire tendering process. And the observation made by the single judge was at para 11, page 37 and 38, Lordship, the important part. Lordship also will come again, once again, I pray Lordship comes to page 38. The relevant portions I'm reading. Lordship have come. It is observed there is no mention about the technical aspect of the bids being examined, even though the NIT had clearly invited bids in a 2-bid system. No discussion is present or materials produced to attest to the fact that the conditions given in clause 3 of the detailed tender dealing with the technical aspect were noted or discussed. Further, the circumstances so and so, I'll leave it, Lordship. This is how a case has been projected before this honorable court. My client stayed away from these proceedings because they thought that defendant was the government department would do the needful to protect the tender.
What was the value of the contract?
2 crore. Lordship, I'm coming. 2 crore 87 lakhs 89,000 and 896.
That is also the reserve price.
Reserve price. This is the same reserve price we quoted. We did not got 1 rupee more. The respondent one quoted.
What is the value of the contract? This is the value.
This is the value of the contract. All 4 contractors quoted the same price. Reserve price. There is no harmony. There is no cartel.
No.
Cartel will.
We are not talking about the reserve price. Had the contract been performed, how much you would have got? 2,87,000. That is the value.
2 crore 87,000 89 lakhs 896. The reserve price only I would have got.
That is also the value of the contract.
Yes,
The estimated value, my lord. That was the estimated value of the contract. It was to be found out that what would be the value submitted by each of the bidders. My lord, after she finishes off, my lord, I can give a reply, joint reply to both the appeals.
And then, Lordship, the tender also says that no price lower than this will be accepted. Estimated and not estimated, these are different things. And every tender contains the word estimated value. Only when there are some certain conditions like some natural calamities or otherwise, then they can go and negotiate and then go. But always every tender has an estimated value. They don't put a concrete and a perfect value on it. It cannot happen, Lordship. And then, Lordship, I wanted to, Lordship would not, I wanted to show through different judgments, Lordship, that Supreme Court has also come to a conclusion that here, now it's when public interest is involved, Lordship, mine is involved because it's a stadium for the underprivileged people of the village. Now, let's say if unsuccessful contractor can go to the civil court and go for under Specific Relief Act and claim damage if any wrong has been done with him. It is there in the judgments.
How much work you have completed?
Lordship, 25%, more than that, but I have put it 25%. Because materials are purchased, labors were had to be paid advance amount, machineries were had to be bought. Those I did not count, Lordship, only the building part I'm counting.
Have you been paid for any part of the work?
No, Lordship, no.
Have you raised any RA bill? No.
No, Lordship, not now.
You have done 25% work from your own funds.
Lordship.
And when was this work stopped?
April 2024.
When after the order of single judge was passed, Lordship.
No, before that.
By an order of injunction by the learned single judge.
Honorable single judge passed always maintained an order that it will be subject to risk and cost to be undertaken by them.
No, that is all right. But
and on 10th of April, Honorable Court passed an order.
Appeal Court.
No, the single bench passed an order saying that Miller, I'll just produce the order sheet.
After the work order was
when the writ was being heard, was there any order of injunction restraining progress of the work?
No, it was only said that the work will be at the cost of the contractor.
That is all right.
That was
subject to the result of the writ and all that.
Yes. And in the appellate bench, my lord, the appellate bench on the first day observed that if the contractor wants to continue with the work, it will be at his risk and cost.
So we did not continue, Lordship.
So practically, I'll show it from the sequence of the order sheets, my lord. Practically, they stopped their work in the month of April 2024. They barely undertook work for 1 month.
No.
I'll show it from the order sheets of the report.
Work was stopped on 6th April.
10th of April. After 10th of April, they didn't proceed.
Which year?
2024.
By that time, only 25% work done, Lordship, because
it can never be, my lord.
And
the commencement was March 2024 was the commencement, and April 2024 they stopped the work. How can 25% of the work can be completed?
Lordship, there was
And
commencement was
in the month of March. 6th of March we came to the court saying that they have commenced the work, and on 8th of March we filed an affidavit indicating the commencement of the work. The Honorable Court passes an order. 10th of April, finally they stop.
Lordship, we continue to do the order after that.
And except in the writ appeal memo, except a statement that they have completed 25%, there is nothing, absolutely nothing.
Lordship,
neither any bills have been produced, neither any proof of work having been completed or undertaken have been produced.
Lordship, my
It
statement
is just a mere statement.
Lordship, a statement in an affidavit is enough for me. Lordship,
Well, on an affidavit, she can claim that the entire High Court building has been constructed by her. Would your Lordship believe that?
Lordship, work order, the moment I got my work order, I continued doing it, Lordship. The work order was given to me on February 24.
I'll show it, Lordship, my lord.
6th April 24, stop.
10th of April 24, after that, my lord, to my instruction, the work stopped. And in fact, my lord, they made a statement before your Lordships, my lord.
When the writ was disposed of?
The writ was disposed of on 7th of 5th of June 2024.
Yes.
And your Lordships had passed an order, my lord, at one point of time, 12th of October, 25th of October, your Lordships had asked the MEPGCL regarding the status of the work. They told your Lordship that the work stopped since last 6 months. Well, I'll just show it from the order sheets of the court.
Madam, you have finished?
Yes, Lordship.
Thank you very much.
Obliged, Lordship.
You have argued the matter remarkably well.
Obliged, Lordship.
Yes. You cannot improve the facts of the case, but you can present it in the best possible manner, which you have splendidly done.
Obliged,
Yes,
Mr.
Mr. Dutta.
My lord, I'll just try to point out the statements made by them in the appeal and the position on record. My lord, the basic contention that have been raised against this Honorable Single Judge's order are on two premises. Namely, that the finding of the Honorable Single Judge regarding cartelization is not correct. They have tried to show that the cartelization was not there. Secondly, the finding of the Honorable Single Judge regard perversity in the regards technical evaluation is perverse. These are the broad two aspects, my lord, on which they have been contesting this appeal. Additionally, my lord, it has been argued that I have not made one Mr. Mustafa Kharkhangwar a party to the writ proceeding, and therefore the plea of cartelization being there will fail. I'll just take your lordship's attention to paragraph 6, which have been multiple times read out to your lordship, but in a partial manner. In paragraph 6 of the writ petition, my lord, I have categorically stated the reason, my lord, for which the Mustafa Kharkhangwar was not made a party. It was because of the fact that, my lord, his payment of earnest money was highest than all. And in my understanding, in the understanding of the writ petitioner, my lord, it was understood to be the bid value of his case. And therefore, my lord, naturally he was not to be made a party. Your lordship will kindly your lordship will kindly come to paragraph 6 once again. They have all read out paragraph 6, but in a very partial manner. Page 76, your lordship will kindly see. Page 76 in writ appeal number 36. They have tried to pick holes in paragraph 6 by saying that I have not made him party, but why he was not made a party, that they have avoided referring to. Am I with your lordship, my lord? Page 76. Paragraph 6, last 4 lines. Had quoted identical rates. Respondents number 8, 9, 10 and 11 respectively had quoted identical rates. As your lordship got it, my lord. Identical rates, as it was found that the earnest money deposit made by all of them stood at 287,990. 287,900. The petitioner's earnest money deposit was 288, and one other Mustafa Kharkhangwar had quoted 290. So naturally, since the bid was his bid of Mustafa Kharkhangwar was higher than all of us, higher than all of the other bidders, we understood that possibly his bid value was the highest. So and the tender conditions indicated that it has to be 1% of the value. Now, in the tender condition, I find that it has to be 1% of the earnest money should be 1% of the estimated value. But the misconception arose because they understood it to be 1% of the bid value. Therefore, my lord, since his bid was highest, naturally he was not made a party because it was settled with supposedly it was settled with the L1 bidder. So that is the reason why Mustafa was not made a party. Now, if your lordship will kindly come to the aspect of cartelization as has been suspiciously lurking in the case, my lord. If your lordship will kindly see the kind of transaction that has taken place. 4 bidders.
No, having participated in that meeting called by the authority to arrive at some kind of a understanding between the tenderers.
I was not called. I was not called in that meeting. All along my contention has been that, my lord, it's a 2-bid system tender. Now, the tender conditions interestingly, the tender conditions indicate, although, my lord, it has been attempted to be projected before your lordship that since it was the respondent number 9 was the L1, so it has to be it had to be settled with them. The tender condition never indicated that it should be settled with the L1. If your lordship will kindly come to page 90. Of the appeal memo in writ appeal 36. Page 93 makes it very clear. And even in the terms and conditions of the tender, which comes under clause 5 of the tender, the same thing has been repeated. Clause 5 ta dekho. Now the second paragraph in page 93, the undersigned is not bound to accept the lowest tender or any tender and may reject any or all tenders without assigning any reasons. Same condition has been repeated in page 96. If your lordship will kindly come to page 96, the last clause, clause 23. Clause 23 also says, the department is not bound to accept the lowest tender or any tender and may reject any or all of the tenders without assigning any reason whatsoever. So therefore, my lord, since it's a two-bid system, my lord, the impression that it generates is that it will be a combination of the two aspects, the technical aspect as well as the financial aspect. To select, the objective is to select the best, not the lowest. Now, if the objective of the tender is to select the best, not the lowest, how do you discount the technical assessment of it? And therefore, my lord, I file a representation before the authorities asking for clarification as on the parameters on which the technical aspect is to be assessed, because the tender conditions do not disclose the parameters on which the technical condition is to be assessed. If your lordship will kindly come to my representation at page 112, the relevant part will be page 113. There are just 3 lines I will read out to your lordship. The second paragraph. Second paragraph, since we have participated in the tender and our tender is valid, the evaluation criteria which as per guidelines should have been mentioned in the tender documents may please be clarified by your office to know on how the submitted tenderers will be evaluated, since the rate quoted by the tenderers are same and evaluation process will be crucial for ensuring transparency and promoting fair competition. This we file a representation before them. What they do? Initially, they say that this is not a relevant criteria at all because every one of you has qualified. But subsequently, my lord, they file a reply, and in the reply they say, page 117, in the reply they say that this representation is being examined at the appropriate level and the reply will be given at due course of time. Please, your lordship may kindly come to page 117. In inviting a reference to the subject cited above, this is to inform you that the representation received at this end by your letter number so and so is under scrutiny by the competent authority. The matter will be informed in due course about the decision by the concerned authority. Well, that decision never comes. That decision never comes. My lord, here is, at this point, my lord, I will try to rely on a judgment of the Honorable Supreme Court, where it has been categorically held that unless if the criteria are not read out, you cannot adopt certain criteria after the rule of game has begun. After the game has begun, you cannot change the rule of the game after the parties have come and they have started taking part in their respective bids. If your lordship will kindly take up the judgment, my lord, that is 1997 1 SCC page 53. I'll rely upon the observations and the eventual decisions in paragraph 4 and 5. May I read it out to your lordship, my lord? May I read it out to you? After hearing the parties, we are of the opinion that the entire process leading to acceptance of the appellant's tender is vitiated by more than one illegality. Firstly, the tender notice did not specify the viability range, nor did it say that only the tenderers coming within the viability range will be considered. Significantly, the tender notice did not even say that after receiving the tenders, the commissioner government would first determine the viability range and would then call upon the lowest eligible tenderer to make a counter offer. What has happened here, my lord? There is no disclosure in the tender document as to how the technical compatibility is to be assessed. Now, after they simply say that all have technically qualified, they summon only the L1, supposedly L1 bidders, and ask them for a settlement. Now, this methodology of calling the L1 bidders, discounting the aspect of technical evaluation, was never spelled out in the tender document. Here it was in the given case, my lord, in this 1997 1 SCC, my lord, it was a case, my lord, the lowest tenderer was called for, and the government asked him to make a counter offer, and on the counter offer, my lord, the tender was settled. That was rejected by the Honorable Guwahati High Court, my lord. Matter went up to the Supreme Court, and this is what the Honorable Supreme Court had to say. Now, the exercise of determining the viability range and calling upon Datta Associate to make a counter offer on the alleged ground that he was the lowest tenderer among the eligible tenderers is outside the tender notice. Fairness demanded that the authority should have notified in the tender notice itself the procedure which they proposed to adopt while accepting the tender. There is nothing in the entire NIT, my lord, if your lordship has the pain of reading it once again, my lord. Nothing is said that on what basis the evaluation will take place, and on what basis the bid has to be settled. Much emphasis has been put from the side of the appellants, my lord, that it will be on the L1 tender. Where is that? Where that condition is read out in the notice? There is absolutely none. I will just next read the paragraph at page 57, my lord, paragraph 5. It is thus clear that the entire procedure followed by the Commissioner and the Government of Assam in accepting the tender of so-and-so is unfair and opposed to the norms which the government should follow in such matters, namely openness, transparency and fair dealing. And accordingly, my lord, in paragraph 7, my lord, the next page, in these circumstances, we affirm the judgment of the division bench in the writ appeal on the grounds stated above and direct that fresh tenders may be floated in the light of the observations made in the judgment. We reiterate that whatever procedure the government proposes to follow in accepting the tender must be clearly stated in the tender notice. In this case, my lord, absolutely no whisper on what basis, my lord, the parameters will be judged and on what basis the tender will be settled.
No, please come to your letter.
Now, if your lordship will kindly come to page 113.
No, you come to your letter, please. 115.
115. Yes.
It has been understood that we have been technically
qualified in the tender. As we meet the qualification criteria of the tender. But the question raised in our letter is the technical.
Stop at that.
Yes.
Now, according to you, you are aware of the technical requirements?
No, I am not aware, my lord. Because my previous letter, if your lordship will see, which is at page 113. In 113, I asked for what are the criteria. I am not aware of the criteria. I asked them to clarify the criteria. Then they say at page 114 that since you have also qualified, so it is of no significance. Page 113, I asked them for clarifying the criteria on the basis of which the evaluation is to take place. And therefore, in page 115, I reiterate that but the question raised in your letter is the technical evaluation of the qualification. This will be required as the financial bid. In the financial bid, the bidders have quoted same rates for the work. So therefore, my lord, my question before them stood that what are the criteria you are going to follow in assessing the technical evaluation, in assessing the technical competence. That they never answer. And the Honorable Single Judge, I will also explain to your lordship, my lord, why Honorable Single Judge had to return a finding that the technical aspect was not gone into. Because, my lord, from the additional affidavit also, my lord, it will transpire that there was no heed paid to the technical aspect of the matter, technical evaluation of the matter. Now, if your lordship will kindly come to the additional affidavit filed. Now, if your lordship will kindly come to the additional affidavit filed by the government, I'm sorry, my lord, the MEPGCL, they have simply annexed the few minutes of meeting. No minutes have actually recorded any finding as to the technical qualification parameters. These are simple minutes acknowledging receipt of certain documents, acknowledging certain shortfall in submission of documents, and acknowledging resubmission of certain documents. There is nothing in the minutes of the meeting whereby your lordship can come to a conclusion that this is the parameter followed and on this parameter they have qualified. If your lordship will kindly come to the minutes that begins at page 7 of their additional affidavit. That is on 27th July. That is the immediate next day after submission of tender. My lord, yes, very unfortunately, my lord, it has been projected before your lordship as if the honorable single judge has recorded a perverse finding. My lord, the order sheets are very clear that honorable single judge had gone into and examined the records of the case. And thereafter, my lord, the finding has come. It is very unfair on the part of the appellants to castigate that the honorable single judge has given a perverse finding on record. Well, lord, I'll explain that. If your lordship will kindly come to page 7, the fourth paragraph on opening of the e-procurement portal, it was observed that the 5 bidders have uploaded documents upon checking the so-and-so. So it was noted that EMD deposit of so-and-so was found that the figure of the deposit is indistinct. However, the committee decided to allow the concerned bidder to submit original receipt so-and-so from the concerned bank for authentication. Next paragraph, the tender committee requested that evaluation of technical bid documents may be taken up from the office of the so-and-so and same may be put up on the new tender committee. They have said that on 27th July, the technical bid was opened and it was found that everyone qualified. Where is the finding? Where is the assessment? Where is the evaluation? They simply say, the minutes simply say that the evaluation may be taken up from the office of some other authority. Next comes the page 12, the meeting dated 21st of August. Now on 21st of August, second paragraph, a comparative statement of the technical bid has been prepared and placed in the meeting for discussion. Where is the comparative statement? My lord, we have annexed a comparative statement in our affidavit in reply, but the respondents have shied away from bringing the comparative statement before this honorable court. And from the comparative statement that we have produced, my lord, we have very well founded ground to say that the respondent 9 could not even have been qualified in the technical round. If your lordship will kindly see the observations and thereafter the resolution. The resolution is, after threadbare discussions, the tender committee has decided that documents which have not been submitted by the tenderers will be sought from the bidders and are to be submitted within 7 days from the date of issue of the letter, along with an undertaking required for authentication of the documents. So, on 21st of August 2023 also no evaluation takes place because they found that some bids are deficient, some bids of every bidder are deficient in certain respects. So, you are to file the documents and the date is fixed for authentication of the document. Where is the question of evaluation? Next, your lordship will find the next minute, which is on page 14, 6th of September, very crucial. The second paragraph, the convener briefed of the process of e-tendering for the work as follows. Now, clause 3, evaluation of technical bid was processed. On this previous page also your lordship has seen that they simply write that it was processed. Now, what is the outcome of that process? That outcome is not to be disclosed, neither before the single judge nor before the writ appellate bench, although an opportunity of filing an affidavit was given. Evaluation of technical bid was processed and comparative statement was put up to the tender committee meeting held on 21st of August. as observed by the tender committee, all bidders could not fulfill the required documents as per NIT. My lord, at this stage, I must also indicate to your lordship, my lord, when before the honorable single judge the records were produced, during deliberation, my lord, it came out that at one point of time, the MEPGCL had taken a decision to cancel the tender process because the bid documents of all the tenderers were not complete in all respect. So at one point of time, they took a decision not to go further and cancel the tender process and to go for a fresh tender. Looking at this, my lord, the honorable single judge directed them to file an affidavit. But still in the affidavit, my lord, they avoided mentioning this and they went on a track to project as if there was an evaluation, which in fact was none. And I'll show to your lordship from these minutes also that the evaluation was not done. Thereafter, your lordship will kindly see clause 7. The bidders submitted the shortfall documents. So, till 6th of September, my lord, they did not have all the required documents which were called for by the tender. How can you now say that on 6th of document we examined, we prepared comparative chart, we processed everything and the technical parameters on assessment, it was found that all qualified? The bidders submitted the shortfall documents as sought for, statement on so-and-so work, average annual turnover along with so-and-so, and the shortfall documents submitted by the bidders were apprised by the tender committee in the meeting held on 6th of September. My learned friend has just now said that it was processed through a number of committees. I would require her to disclose before this honorable court which are the committees, and when the MEPGCL does not say so, how she is privy to this statement that it went through a number of committees from which, my lord, the comparative assessment was drawn and the technical aspect was evaluated and the result was declared. Is she a party of that particular committee, or her client party to that part of that committee? That is why she can vouch for the statement that it was done. Now, if your lordship will come to the next paragraph, after scrutiny, what they scrutinize? They scrutinize only the documents, bid documents that are furnished. After scrutiny by the members of the tender committee, it was found out that all bidders are qualified on technical bid. On what parameter? On what parameter this finding is recorded? And to expedite the process, the tender committee has decided to allow for opening of the financial bid on 8th of September. Now, if your lordship will come to the 8th of September minutes, which is at page 17, that makes a very interesting disclosure. If your lordship will kindly read the conclusion. Has your lordship found page 17?
Yes.
The tender committee members, after the observation and discussion, agreed for further detailed evaluation. So on 8th of September also, the committee members were addendum on the point that there was a scope for further evaluation. Further evaluation for the next due course of action. And after 8th September, nothing is on record. Whatever had been done. So what is the wrong if the Honorable Single Judge has recorded that on 7th of February, the technical aspect was not gone into? My lord, it is very easy to raise finger on some finding, but to sustain it, my lord, it is very difficult. The Honorable Single Judge has examined the records. I will show it from the order sheets. The records were produced during the course of the proceedings. Honorable Single Judge examined it, asked them to file an affidavit, noticing these illegalities, my lord. Now, if your lordship will permit me to read out the order sheets.
Yes,
my lord, the chain of events I will just indicate. The first order is of 27th of February. 15th of February.
Please answer this.
Yes.
26th July was the last date.
For submission.
Yes. On 1 o'clock.
Yes.
On the last day, all five
Fine.
offers tenders were submitted. 27th was the date for
Opening the tenders.
for technical evaluation.
Technical evaluation.
You were present.
Yes.
Right? Whether the evaluation was done, not done, we are not going into that question. You were present on that day when
Yes.
the technical evaluation started. Now, why you waited up to 4th October 2023.
My lord, the answer is in page 17 of the additional affidavit. Because they said that further evaluation will be done. When I found that no further evaluation was being taken up, nor the contract order was being issued, then in the month of October, my lord, 4th of October, I first wrote to them. 8th of September proceeding minutes, your lordship will kindly see, which is at page 17, annexure A4, to the affidavit filed by the government. The tender committee concludes that further detailed evaluation for the next due course of action will take place. Thereafter, nothing is taken place. Well, lord, in the
8th September.
8th September, because
Page.
page 17 of the additional affidavit filed by the MAPGCL.
Then on 3rd November 2023, that is at page 51, 117, you went on to write.
No, before that, my first representation was on 4th of October, page 112. 8th September, they say that further evaluation will take place. Nothing happens. I write to them on 4th of October. Page 112.
18th October, you write, page
No.
115,
18th October is
that
my...
we have been technically qualified in the matter. That is the end of the matter?
No, my lord.
Why?
Because the tender condition says that it will be a combination of two factors. Your competence vis-a-vis the price. It is not, neither of the components are single-handedly determinative of the winning bid. Winning bid will be a combination of price as well as competition, as well as technical competence. Because in the tender conditions, they have said that merely becoming L1 bidder will not make the bid win. So it is a combination of two aspects. The bid has to be a viable bid, and secondly, the person bidding the viable value will also have to have a competence, technical competence to execute the work. So the technical aspect of the matter does not lose significance until the work order is issued. That is my respectful submission before your lordships. And that is the reason, my lord, I say, right from 4th of October, 8, and it is not my understanding alone, my lord. Even the MAPGCL till 8th of September was on the same track. They were also thinking on the same line. That is why they write in the conclusion that further detailed evaluation will be decided. They were also thinking in the same line. But surprisingly, my lord, something is changed in between thereafter. And that something is not on record. It is anybody's guess, my lord, what could have been who could have been that something. Now, therefore, I write on 4th of October. And on 4th of October, and why I did write this 18th October letter, that is because of the response I get from them on 17th of October, which is at page 114. Page 114, MEPGCL tells me that committee emphasizes that you have qualified and therefore technical evaluation is of no significance. Therefore, I write on page 115 that it has been understood that we have technically qualified. But what are the parameters? Please disclose. Now, if your lordship will kindly permit me to read out the order sheets. 15th of February, the tender was... Has it been placed? If your lordship will kindly permit me to read out the order sheet. My lord, I have a serious task of defending the finding of the Honorable Single Judge because it has been alleged that the finding is perverse.
When was the contract executed?
Pardon, lordship?
Contract executed? Agreement?
Agreement was not executed. An order was passed on 15th of February.
That is the agreement.
And that 15th of February was the order passed, awarding the contract to respondent number 9. I came to court. Honorable Court issues a notice on 27th of February, making it clear that...
Was the financial bid accepted at an earlier point of time and work order issued later or at the same time? So we take it as 15th February as the date of execution of the agreement.
No, my lord, if I can just read it out to your lordship, 15th of February letter is very, my lord, 15th of... February, your lordship will find it at page 121. It asks the contractor to attend the meeting to sign the agreement before starting the work. If your lordship will kindly come to page 121, it will be third paragraph from top. Second paragraph says the work should be started immediately in consultation with the superintending engineer, so and so, and it should be completed in all respect within 18 months. Next, please attend the office of the undersigned in any working days during office hours for signing the tender agreement. We do not know whether a tender agreement was signed or not. At least the MEPGCL affidavit does not disclose. But now, and my lord, in the tender, some post tender conditions were also to be complied with.
Which
your
page
lordship
you,
will
which page you read?
page 121. Page 121, third paragraph. Please attend the office of the undersigned in any working days during office hours for signing the tender agreements. Neither the appellant in Writ Appeal 38 nor the government have disclosed whether or not any agreement was signed. Now, if your lordship will come once again to the tender, my lord, at page 93, your lordship will find that there are certain post-tender conditions also which have to be complied with before the work could really begin.
Mr. Datta will review again on Monday.
If your lordship would kindly permit me to, if I fail, my lord, if your lordship will kindly permit me to come on VC.
Yes.
My lord, I have been here for last 3-4 days.
Yes. You will be able to conclude on Monday?
Yes. Yes, my lord. Yes.
Monday the matter is fixed.
If your lordship gives it a precedence on the list, my lord, at I says
some matters, I think.
Some matters, usual matters, are some specially fixed.
if your lordship gives a precedence just as
How much time you will take? But you have to.
I think by half an hour I'll be able to conclude.
And
I'm only to bust the myths that have been created before your lordship by the appellants.
No. Then any other counsel to address the court?
No, my
After
lord.
you?
No.
We can conclude hearing.
Yes.
Lordship, I'll be given the opportunity to counter his argument, Lordship. And before I finish, Lordship, today...
No more facts. No more facts.
No, only on the facts, Lordship. Lordship,
No,
in the
not
15th
facts
of
on
February,
reply.
Lordship, I'll point out today only that 15th February, that order of the that order, and the last line is that this work order is final, and along with the LO shall form part of the tender agreement. It is there.
You see on reply, no more facts. Unless certain facts which you were not aware of in the pleadings or papers before the court have been brought to the notice of the court. Otherwise, argument on facts is closed.
Lordship,
You can deal with the law.
Agreement is there. This is 15 February is the agreement. This is the last line. This work order is final, and along with the LOS shall form part of the tender agreement.
These will form part of the tender agreement. This itself
We have become aware of the facts in the greatest detail and in the greatest depth. So we have to decide that whether how valid the execution of the agreement was.
I may be given an opportunity to come on the law points only.
My lord, I'll try to be here physically. If I fail, my lord, then only I'll ask your lordship's leave to be on online.
All right. List these appeals for further argument on 19th.
If your lordship, my lord, gives a precedence on the list.
At 12:30 p.m. Marked at 12:30 p.m. You finish by 1:30.
Yes.
45 minutes and
15
Mrs. Parveen 15 minutes.
Deeply obliged, my lord.
Marked at 30 p.m.
I may also, my lords, briefly rejoin only on legal points.
Why?
5 minutes, my lord. That's it.
On law only, no more facts.
On law points only,
Yes.
not on facts. My lords have already
Unless
done.
you were taken by surprise by disclosure of some facts not in the records of the case.
My lord, I'll not argue anything, my lord, beyond the records, my lord. I'll never argue, my lord. Well, we have been following that Calcutta High Court tradition in Guwahati, Calcutta High Court being parent High Court, my lord, we have been trained not to go beyond the records, my lord. Unless, my lord, we take specific leave from the court. My lord,
that is everywhere. Why Calcutta High Court?
my lord, no, my lord, that is the tradition we have been following here. I will not go beyond the records, my lord.
Yes.
May it please your lordships. Your lordships, I have a request to make, lordship, on item number 5 of the list, your lordship. Lordships, the conducting counsels are both from outside of station, your lordship.
Let the matter be called.
My apologies, your lordship.
This is not mentioning time. Yes.
Item number 3.
May it please your lordships. Lordships, in this matter, your lordship had directed the state government to conduct an inquiry with regard to the road bridges and overloading of trucks.
Yes.
Inquiry has been
8th
conducted,
of
my
May,
lord.
a report has been submitted by the respondents. I pray for 2 weeks' time, lordship, to file a counter to the same, a response to the report, because there are certain anomalies and certain facts which the petitioner also would like to bring to the notice of this honorable court, since he was a part of the inspection at some of the places.
These the way bridges everywhere or along the border?
Lordship, way bridges are there in, across the state in different districts. It's not only the borders. So there are certain points, like in in Khasi Hills and Jaintia Hills, the petitioner could not be present for the inspection due to security reasons, and he had written a letter to the Commissioner of Transport to that effect. In Garo Hills, he has attended, and there are certain conditions, there are certain points that he would like to bring to the notice of this.
What is the gist of the report?
Just is that there is no overloading, but
My lord,
the number of vehicles were
your
very
allegation
less.
was, my lord, as regard to the overloading of trucks, my lord. So the my lord has already ordered for inspection of all these way bridges, my lord.
Done.
Inspection was done. Report has been filed, my lord.
Copy given.
Copy given.
Yes, Lordship. I may be permitted to submit a response, Lordship.
What is your initial response?
Initial response, Lordship. The first place where the inspection took place, merely 3 to 4 vehicles had passed. It was not a heavy moving time period. Second, Lordship, the second way bridge, Vajeng Doba, the name of the place. Vajeng Doba, Lordship, there was just a point at which the inspection was taking place. There was no way bridge at that particular place. For Khasi Hills and Jaintia Hills, he could not attend the inspection due to security reasons.
For overloading, what would be the loss to the state? Tax.
Yes, Lordship, revenue loss.
That is the point.
Yes, Lordship, that is the point. And I have already portrayed all those points with regard to the previous years by way of the Comptroller and Auditor General's report. On the basis of the report, after seeing the reports, your Lordship had directed for an inquiry.
My lord, those are old reports, my lord. And their main PIL was, my lord, regarding the Dalu Way Bridge. And we have already filed an affidavit, my lord, stating that the Dalu Way Bridge is already in operation, my lord. And thereafter, my lord, they have come with an allegation that there is overloading of vehicles.
Lordship,
And my lord has already given
Order sheet only.
Lordship, this honorable court is a court of record. I may be permitted to
order
file
for
an affidavit.
inspection.
I can't argue the matter just like that.
What is a court of record? Court of record is a court for storing affidavits. You tell us, what is court of
It's
record?
not just for storing affidavits,
Then?
Lordship. A court of record is a court whereby whatever is produced before this honorable court, that can be taken as an evidence and nobody can question those documents.
It has inherent contempt jurisdiction.
Indeed, Lordship. It is
Contempt
under
jurisdiction.
215, Lordship.
That is a court of record.
Yes, Lordship. Under Article 215.
A Tehsildar's office is also a court of record. That is not a court of record. Court of record is a court with inherent.
Contempt jurisdiction.
28 weighbridges.
My lord, in 24 weighbridges, my lord, inspection was conducted, my lord.
24.
24, my lord. As per this list, my lord, may
At
kindly
page
see
5.
page number 9.
But
Page
the,
5 is
our order says 28.
Yes, Lordship. In the previous, this is the second round of litigation, Lordship. In the first round of litigation,
4 were done.
Lordship,
4 were done.
My
in
lord,
the first round of litigation, the state government itself submitted a report stating that there are 28 weighbridges. And now in this PIL, they are saying that there are 24 weighbridges.
All right. This is a public interest litigation by a social worker. Drawing attention of the court to alleged misconduct on the part of government officials in operating 28 weighbridges across the state. Full stop. The complaint is that overloaded goods carrying vehicles are allowed to pass without proper payment, causing loss of revenue to the state. Paragraph by our earlier order, orders in this matter, we had directed the respondent state to carry out an extensive inquiry into the matter by inspection of the weighbridges in the presence of the petitioner. Causing loss of revenue, fee and charges. First paragraph. Full stop. Learned advocate appearing for the state has filed a report dated 8th May 2025 indicating the action taken. Full stop. According to this report, this exercise was carried out in 24 weighbridges. Full stop. It was found in none of them any overloaded truck was found to pass. Full stop. A copy of this report has been furnished to learned advocate Dr. P. Pal, learned advocate for the petitioner.
P. Agarwal, Lordship.
P. Agarwal, yes. Learned counsel disputes the correctness of this report and wants to file a rejoinder. Full stop. Such time is granted. Such rejoinder may be filed by 6th of June, list this public interest litigation on 13th June.
Deeply obliged, Lordship.
Number 4.
Yes, please.
My lord, this is with regard to the Harijan Panchayat, my lord.
Sorry?
My lord, this is with regard to the allocation of land, my lord, to the community belonging to the Harijan Panchayat, my lord. Negotiation, my lord, in the past few occasions, we have apprised this court that negotiation with regard to allotment of additional lands are being made, my lord. And we are still in the process of negotiating, my lord, with the union as well as with the other side, my lord. So today also I'm praying for further time, my lord.
So we will reiterate the same order.
My lord.
Till 25th June. Identical as 8th 425 order.
Deeply obliged, lord.
Number 5.
May it please, Your Lordships. Your Lordships, this matter, the conducting counsel from both sides, Your Lordships, they're from out of station, Your Lordships. Your Lordships, they've requested.
Have you taken consent?
Yes, Your Lordship.
When?
Your Lordships, I got instructions from the appellant counsel, Your Lordships, that they've taken consent, Your Lordships, if this matter can be taken up on the 18th of June, Your Lordships.
All right. By consent of learned counsel for the parties, this appeal and the corrected application are adjourned till 18 June.
Much obliged.
The others you have taken from the warning list. So it's all transferred to Monday's list.